Perfect. Good morning, everybody. Thank you so much for joining us for our July webinar. We've got a full house this morning from participation side as well as our panelists. A lot of the faces are quite familiar. One or two are relatively new. During the course of the presentation, please feel free to post your questions, comments, thoughts in the chat function. If you've got any questions, raise your hand. If you've got some background noise, please do mute yourself in the background. That will be appreciated. A copy of the recording as well as the details of all the speakers will be made available on our website afterwards, and I'll share everybody's details in the chat function as well. Just on an official note, I'd like to thank every single one of the speakers this morning for taking time out of their incredibly busy days to chat to us on our webinar. I know that some of us are a little bit tired of hearing about the solar topic, but I think that it's continuously evolving. And I think we've got a very good coverage today of pretty much everything that you need to know. For those of you that have watched me on webinars or have known me for a while, you know that I'm not really someone for color. So I've even chosen my nice sunny jersey this morning to show you the importance of sun and solar. Ladies and gents, please just do accept the apologies of Philip from Reghard Consultants. Unfortunately, he would not be able to join us this morning, but any questions that you might have from a structural perspective, please do let us know and we'll pass it along to Philip. He does extend his apologies. All right, on that note, I'm going to hand over to Carl, Nicole, and Matthew, and from there we're going to go straight into a discussion from Reghard.
Right, thanks, Zerlinda. I just want to check that everyone can hear me because I'm presenting.
Done, Carl, 100%.
Okay, perfect. Thanks, Zerlinda. Good morning, everyone. I hope everyone is doing well this morning. Thank you so much for tuning in to our webinar. This will be recorded and published to our YouTube channel, so please turn on post notifications so that every time we publish a video, you will be notified. And also subscribe and please leave a comment. It does help. If you haven't already, please also do subscribe to our newsletter, so that way you can keep in touch with the TVDM Consultants team, as well as see all of our latest resources. Then please also don't forget to check out the new Our Neighborhood platform. And if you have any questions, please feel free to send me an email or take out the managing agent or the common property package at no expense of your own. If you're looking for training, then also please check out Strata and Trustee training in conjunction with TVDM Consultants. I'll post a link in the chat below. Then Let's Get Physical is also returning and happening in George on the 4th of August at the Protea Hotel, the King George one, I believe. If you're in the area, then please don't miss out. This Monday, which is going to be the 18th of July, TVDM Consultants will be hosting a 67-minute webinar whereby you can ask any question related to the community schemes, and stand a chance to have it answered by one of the experts on our panel. Stay tuned to our social media accounts as we will be releasing speaker information very soon. If you'd like to submit any questions or sign up, then I will also add the links below. And I'll now hand over to Nicole now to introduce the speakers. Thank you.
Thanks.
Good morning, everyone. Oh, sorry, Z.
Sorry, Nicole, just to interrupt you, Carl, I think you might be sharing another screen. I'm not too sure. We don't see anything on our side. If you don't mind just doing that in the background while Nicole's talking.
Can you guys hear now?
No, not yet, I don't think.
Don't stress too much. It's just everyone's faces, which we can see now.
Okay.
Anyways. Nicole,
All
back
good.
to you.
Cool. I'm just going to keep my video on for now because I've got that famous your internet connection is unstable, because I am one of those lucky people having load shedding now. But I mean, when are we all not a bit unstable? So let me go ahead and introduce our fabulous panel for the webinar today. So up first, we have our academic hard hitter, Mr. Reghard Brits, or should I rather say Dr. Reghard Brits, who is an attorney and conveyancer at Brits Dreyer Incorporated in Bellville. He holds a BCom law degree, an LLB degree, and his doctorate from Stellenbosch University. After completing his doctorate, he was a postdoctoral researcher at the South African Research Chair in Property Law at Stellenbosch University from 2013 to 2015. So Zerlinda and I also spent some time there when we were at Stellenbosch. And then from 2016 to 2021, he was a senior lecturer and associate professor at the University of Pretoria, after which he left full-time academia for legal practice. I'm sure that was quite a big flip. However, he remains involved in academia part-time as an extraordinary professor at the University of Western Cape and a research fellow at Stellenbosch University. His research focuses on real security rights, as well as general property law, insolvency law, and consumer credit law. He is also the author of Real Security Law, published by Juta in 2016, as well as a co-author of the 6th edition of Silberberg and Schumann's The Law of Property, published by LexisNexis in 2019. Hence why I said the academia hard hitter. And then up next, we have Michael Schaefer, who is the former director and co-principal of the National Property Group Trafalgar, where he was the driving force behind Trafalgar's financial services capability, while also overseeing Trafalgar's Gauteng and Western Cape operations for 18 years. After identifying an opportunity in the market to better cater for bodies corporate and scheme finance, an area grossly underserviced, he started ZFIN early in 2020. Michael has more recently added the executive managing agent service and offering to ZFIN's bouquet of offerings, and one that is growing traction as one of the few truly independent companies offering this service. Michael's background and experience in property management and property financial services positions him perfectly to assist schemes with their financial requirements and associated challenges. Then we have Zerlinda, who I'm sure everyone knows by now. Zerlinda graduated from the University of Stellenbosch with the BA LLB and an LLM cum laude. While completing her LLM thesis, she specifically focused on the constitutionality of sectional title rules. After graduating, Zerlinda joined Pam Golding Property Management Services as a managing agent. Following this practical experience, Zerlinda completed her articles with Marina Constas at BBM Attorneys, followed by her appointment as a specialist community schemes consultant with Professor Graham Paddock at Paddock's. Before she co-founded TVDM Consultants, Zerlinda went back to her roots as the general manager of Pam Golding Property Management Services. Up next is Dilen Heerschop. Dilen Heerschop heads up the Community Scheme Litigation Department at De Toy Burger Attorneys. He specializes in the law pertaining to community schemes and all concomitant compliance issues. He has obtained his master's degree in estate planning law, giving him a keen insight into financial aspects relating to community schemes. Then Glen van der Vyver. Glen runs a family business and has been in the solar industry for 34 years. They are the longest standing manufacturer of solar geysers in South Africa and one of the few companies who design and manufacture their own solar photovoltaic equipment. Given the long-standing history with solar geysers, when the word hit the ground of the new B-rated geyser in the mid to late 2000s, they felt the opportunity was right to re-engineer their solar geysers with the view of focusing on the conventional electric geyser industry. Then our last three, Abrie Snyman. Abrie is a seasoned town and regional planner, having gained extensive experience as a senior town planner at the City Council of Pretoria and the Department of Housing. In 1998, he founded Multiprof Property Intelligence, a versatile consulting enterprise offering a wide range of services in the property industry. For over 32 years, Abrie has been a trusted consultant utilizing his expertise to connect various aspects of the industry. His services include town planning applications, as-built plans, complex building audits, sectional title advice, exclusive use area plans, as well as civil engineering, valuations, and property inspection services. He's very passionate about sharing his knowledge and conducts popular training sessions on relevant topics for the sectional title fraternity. Beyond work, He enjoys backpacking adventures and has visited 59 countries to date. Abrie is also a couch surfing ambassador for South Africa, and he actually let us know that he's just planned his next trip overseas to the exciting Balkan countries in a few weeks. So that's very, very exciting. And then Willie Roos from Stratifen. Willie has practiced as a property attorney for over 20 years. He was involved in sectional title management for over 8 years, where he dealt with various municipal bills and interacted extensively with local communities. Willie started Stratifen in 2014 with the goal of assisting bodies corporate with their funding without catching them in the debt traps they often found themselves in. Stratifen strives to be a fair and equitable money provider for the sectional title industry. And then last but not least, our insurance expert for the day, Mike Addison. Mike completed his schooling at Pinelands High School in Cape Town before going on to pursue an associate's degree in banking and finance. He kickstarted his career off with Barclays Bank in 1979 and started his way up the corporate ladder. He now specializes in sectional title insurance and has been doing so for 25 years. Mike founded Addison in 1995 and soon began to focus on the community schemes arena, noticing a gap in this market. Addison is now a nationwide business with offices in Joburg, Durban, including Port Shepstone, and its head office in Cape Town. They are well known in the industry for their expertise and their thorough leadership in the community scheme, risk, and insurance environment. And now you've heard way too much from me, and it's on to Matthew before we go to our speakers.
Thank you so much, Nicole. It was an excellent introduction. I have nothing further to add from my side. So Zerlinda, do you want to kick us off and let's get started on the solar topic?
Perfect. Ladies and gents, I thought we would use the opportunity to really introduce the speakers, because we've had a couple of webinars on this topic before, and we've been focusing a lot on the content. You know, is it an exclusive use area? Is it a conduct rule? What must be in the conduct rules? Is it a lease? Is it a servitude, etc., etc.? Today, I really want to hear from the speakers, which is why I thought we would spend as much time as we did on the introductions. I've also shared everybody's contact us page on their websites on the chat function. If you'd like email addresses and phone numbers, we can give that to you as well. Now, I want to hand over first to Reghard. We're going to be focusing on ownership of solar panels once it's been installed, from both an immovable perspective and a movable perspective. We're going to chat about the real security element, which is an expert on, which is the financing. And I'm going to then hand over to Michael and Willie to please contribute to that discussion when it speaks about financing and ownership. And then we're going to chat about the insurance aspects, where Mike is going to come in. Glen is going to chat to us about his views on who the installer should be, the body corporates or the individual owners, and what that setup should look like. I don't think you're going to hear too much from us today, because we have spoken about the legal elements quite a bit. And then, of course, I'd love to hear if there's been any interesting installations from your side as owners as well, if you'd like to take us through those processes. Marion, I know that you've got some thoughts there. Paul, I know that you've also got quite a lot of information to share, so please feel free to share with us. On that note, Reghard, if you could kick us off.
Good morning, everyone. Thank you very much, Zerlinda, and the rest of the team for inviting me and being willing to hear what I have to say. Hopefully, I will be able to contribute a little bit to these discussions. So as Zerlinda said, the question that I just want to touch on this morning is, who owns the solar panel after it has been installed? And for many people, it might not seem like a obviously problematic question, but there's quite a bit of confusion or uncertainty in South African law, rather, when it comes to any object which is installed or attached to another object, like a building or land in this context. And just to give you a little bit of background, in South African law, we have this principle called superficies solocadet, which is a Roman law principle, so it's a Latin phrase, which basically means that the owner of land is always automatically also the owner of everything that is permanently attached to the land. So obviously a building is a simple example, but there are some examples of things that are attached or installed that are very difficult to determine whether it really is part of the land or whether it has remained an independent movable object. So that is always a question. And in our law, there's been many, many court cases over many, many years in dealing with many different types of objects and situations where the courts always had to figure out whether this object became a fixture, is the term often used, a fixture or an accessory of the land or the building in which it has been installed, or whether it has remained movable. So this question is important for many reasons. For example, it could be important for insurance purposes. It is very relevant for financing purposes because, and we'll speak about it again a bit later, but obviously a creditor who sells a solar panel in terms of a credit agreement would typically retain ownership of it or would want to retain ownership of it. So that's very important then, whether the attachment of that solar panel to the roof of a building, what is the legal effect thereof? Does it mean that the solar panel now automatically becomes part of the building, and in other words, the owner of the building also owns the solar panel, or does it remain a movable object and still belongs to the financing company, to the creditor? So those are some of the tricky questions that often come up. And in the sectional title context, there's an extra problem, I guess we could say. There's an extra additional questions that arise. With normal property, it's already difficult, normal individual properties that are not sectionalized. But in the sectional title context, it's a bit more tricky because we, as I'm sure all of you know, the common property, the land of the complex, really, and everything on the outside of sections, of units, belong to all of the owners, in other words, the body corporate, in undivided shares. So there's a bit tricky because we're not dealing with situations where the individual owners also own the actual land. They only own their section or the unit, which is the inside of their building. So there's some tricky questions there about what happens if a solar panel is installed on the roof. Who does it belong to? Does it belong to the body corporate? Does it remain the property of whoever was the original owner of it, like the financier or the person who purchased it cash from a supplier, or does it become the owner of the body corporate? So there are some tricky questions there, and it's not always easy to answer these questions. But I'm going to just try to give a bit of background on what the current law says. Even though the current law is is a bit confusing, there are a couple of things that we can withdraw from the current law to give us some direction. So I'm going to look at this basically from two perspectives. My academic side, as an academic, I'm going to cause problems. That's what academics usually do, cause problems by highlighting some of the problems. But from a practice perspective, I want to look at it from basically a risk-based approach. In other words, how can we mitigate our risks? What will the courts probably say if this comes to a court, basically? So as an academic, I would like to make all sorts of arguments on what I would like the law to be. But as a practitioner, I'm going to look at what the law currently says and what we can use from that to try to give us a little bit of certainty on what will happen if these questions actually do arise in future. I mean, one can just imagine a situation where a dispute arises, where different persons all want to lay claim to the solar panels. It might be very valuable depending on the situation. It could be millions of rands worth, depending on the scheme or the building on which it is installed. And you can imagine if that different persons would like to get their hands on it. For example, the mortgage creditor might want it. The person who financed the sale of the solar panel might want it. The owners of the units might want it. The body corporate might want it. I mean, there are different persons involved who would like to be the owner of it. So we need to figure out who the real owner of the panels are. So the basic principle in law, and I'm going to first I'm going to explain it from the perspective of normal property first, because in the sectional title context, there's a little bit of a kink there. So I'm just going to leave that aside, and perhaps some of the other sectional title experts can jump in. I'm just going to first start with the basics of the existing law that applies to normal property. So we can just get that first. So the basic principle in law is that the courts will look at whether the object, in this case the panels, were installed on the property with the intention to remain there permanently. Now, permanently doesn't mean literally forever and always. It just means indefinitely, with the intention to serve the property permanently and become an integral part of the use of that property, basically. And to try and answer that question is not that easy. As soon as you start looking at examples, it can become very difficult to give an answer to that question, whether it was intended to remain there permanently. So there are three factors that the court usually looks at. The first is the nature and object of the attachment. So the type of the thing that you're attaching, the solar panel. Is it something that would typically become part of a building, for example? Is it something that serves the building permanently, etc., etc.? And I don't want to make this into a long legal lecture, so I'm not going to go into all the details, but you look at the type of object that you're dealing with and you ask yourself, is this a type of thing that would normally form part of a building? So if you can take a window, for example, or roof tiles or whatever. With all these things, you can ask yourself, is it something that usually forms part of a building or not? Now, with solar panels, I guess it's a bit debatable. So it's because it's a relatively new innovation, but it's not that new. So we're at kind of at a tipping point where in the past, it might have been a unique luxury object, but as time goes by, it becomes more and more part of most buildings. I mean, I can just imagine 10 years from now, practically everyone will have solar panels. I can just imagine it will become so part of what it means to what a building is that it will probably be part of a building. Okay, and the next factor then is they will look at the way in which it has been attached. So the technical way in which it has been attached to the property. This is not always a very useful factor because the question there is basically whether it can be removed without causing damage. Now, this is not a very useful factor because in this day and age, practically anything can be removed without causing damage. So it's not really always a useful factor, but it is still something that courts look at. And I'll say something about that again. The third factor is then that they will look at the intention of the persons who installed it or the owner of it to see what did they intend. Okay, so this is the basic three things that the court will look at. And over the years, there's been many cases on how to apply these factors, which factor is the most important, etc., etc. I'm not really going to bore anyone with how that plays out because it can be very messy. At the end of the day, the courts will always look at the circumstances of each case to try and figure out whether the object became part of the building or whether it remained a movable object. So it's difficult to give kind of a final answer in advance before a court looks at it, unfortunately. So let me just say a little something about different situations that could arise. So even though I can't give a final answer now about whether a solar panel will be movable or immovable, because there are different factors in different situations that could impact the answer. But I'm just going to briefly mention three things that we can take from the current law, what the courts have found that could give us a bit of direction on how to think about this issue. So the first thing is that if a solar, I'm just going to say solar panel, but it can be anything else. But for purposes of today, I'm just going to stick to solar panels. If a solar panel is installed by a tenant, so someone who's not the owner of the land, so a non-owner of the land, it will usually be a tenant, but it could be other situations also. Anyone who's not the owner of the land installs his own solar panel onto that land. Then the assumption is that it was done for a temporary purpose, because usually a non-owner won't attach something of his own permanently to someone else's property. And in the lease context, that is quite established. So in the lease context, it's established that a tenant, if they attach something to the lease property, they are entitled to remove it before they leave, before they move out. So before the lease expires, they would usually be entitled to remove it and take it with them, unless the contract of lease says something else, which might also be the case. But if the contract says nothing, the general rule is that a tenant can take his installations with him as long as he doesn't cause damage to the property. So in that case, the law is relatively clear. It's not such a big problem. The next situation is if someone installs his own solar panel into his own property. So my own house, and I buy the solar panel cash, it belongs to me, and I attach it to my own property. Then the assumption is the other way around, because then the assumption is that, or the presumption rather, that I probably attached it for permanent purposes. So an owner of his own property will usually attach something permanently for his own purposes, or indefinitely at least, until the natural life of the object has come to an end. So this is only a presumption. It could be disproven. So it could be possible that it's actually not the case, but the presumption at least is that usually if the owner attaches his own solar panel to his own land, to his own building, then the courts will possibly find that it has become part of the building, unless there are other circumstances in the facts that indicate otherwise. So that is just the general presumption in that situation. Now, the third case is if the solar panel is financed. There's another exception here. If a solar panel is financed in the sense that a creditor has remained the owner of it. So the typical arrangement where you have to pay it in installments, and only after the final installment has been paid, then you become the owner of the thing you purchased, which I believe is very common in this context. It's a very common in many contexts in South African law. It's a very common type of transaction, or it can even be a type of lease in that sense, where you lease it, and then at the end of the lease term, you can become the owner of it, or perhaps exchange it, or whatever the case may be. Very similar to with motor vehicles. So in that case, even though it's a bit controversial in the case law, and many of the authors are not really happy with the way in which the courts deal with it, but the case law is clear that in cases like that, courts will almost invariably find that it remained a movable object, because the owner of the property is the financier, the creditor, and the creditor likely would not have intended to lose his ownership. And provided, of course, that it is possible to remove the object, which in this case, probably in most instances, it will be possible to remove it. And the courts are quite generous with what they mean by whether it can be removed or not. So they are not too technical about it. If it's at all possible to remove something without serious permanent damage to anything, then they will allow it to remain immovable, basically to protect the owner of that movable, if it is the creditor, for example. So there's been many cases that confirms this over many years. It's the way in which the courts explained it is not always satisfactory and necessarily from a theoretical perspective, but practically at least, we can comfortably say that if a solar panel is financed, then it will not become part of the land on which it is attached. Okay, so those are basically the three types of scenarios where we have a reasonable clarity. It does not, there can be some inconsistencies sometimes, or even contradictions. For example, you could have a situation where you have two solar panels on one roof. One was purchased cash by the owner of the land. The other one is financed. So the one is movable, the other one immovable. The one is still a loose object, well, legally speaking, a movable object, whereas the other one might have become immovable, which seems like a bit of an odd thing if you think about it, because they look the same from the outside, but legally one is movable, the other one immovable. So there's some contradictions that could arise in the way the law currently operates, but we can leave that aside that's something for my academic mind to figure out separately. But from a practical perspective, at least, the courts will focus a lot on the intentions of the parties. That's kind of the main point. Now, in the sectional title context, I mean, some of the others can also jump in here, but just a very brief word before the others jump in. Here, it's a bit tricky because the solar panels will I assume, will practically always be attached to common property. So there's no, because the outside of these buildings are always common property. Even the top of the roof is common property, which I think for many people seem very odd to think that my roof on top of my little house is not even mine, or the outside at least. So there it's a bit tricky because it's always, in other words, it's always attached to property that belongs to the body corporate and not to the unit owner. So legally, I mean, there's that throws an extra consideration into these questions that we can speak about. And there's no case law on the attachment of movables to sectional title property that I'm aware of. So these questions have never been answered by the courts in the context of sectional title property. So we have to kind of take the existing law and extrapolate it to how we think it will work in the sectional title context. But I think from my side, that's enough background for now. So I see someone is asking about DSTV dishes already. You know, the considerations are roughly the same for anything that you really attach, but I'm going to leave that to the other sectional title experts to jump in here.
So just a note from me, and Paul's incredibly knowledgeable when it comes to this type of thing in compliance. And he spoke about, you know, we always look at the panel, but what about the DB board, the wiring, and all those fun things as well? So there's so many considerations.
And the batteries and the inverters, all of those things.
Yeah.
It's a bit different because it's installed probably on the inside of the unit. So, but I mean, it's similar questions.
Yeah, and then you take into consideration that whole pipes, wires, cables, and ducts clause in the STSMA, where even if it serves a section, it's still a body corporate responsibility. So this is super, super complicated. I'd like Willie and Michael to come in with regards to the whole financing aspect and the consideration of movable. And when you offer this product, you know, do you keep in the back of your mind that it's a movable as opposed to an immovable, and how the clients, the body corporates you work with think about that? And then to ask obviously Mike to come in with regards to insurance, and then Abrie and Glen to come in with the whole argument of, you know, can you take your solar panel off? Like, is that even a consideration? Do you consider it to be a movable item? And then if I can ask Dilen to comment on some of the sectional title aspects specifically. But Michael and Willie, if the two of you wouldn't mind passing some comment in regard to the financing issues and the movable versus immovable concepts there.
Thanks, Zerlinda. Yeah, thanks, Reghard. It was an awesome discussion that we had also 2 weeks ago when we started this discussion as well. And you've taken this now to everybody so that people can understand the complexities surrounding all of this. So in respect of the financing, we have created a specific product where ownership is reserved in our contract. Like Reghard said, because that is the only way that we can, or that is the best way that we can actually have security in respect of the equipment that is being installed on the common property. So our product is a lease product where the equipment is purchased and then ownership is retained by a company that is ours. And it is then leased over the period, and on a final installment or final payment, ownership is then made over to the body corporate in that respect. So our product is specifically focused on bodies corporate that install equipment on their roofs on the common property. It is not an individual type of product where owners can individually purchase this equipment, but it is for the greater scheme to install and utilize in respect of common property usage. Or if they want to then have people have their own inverter and battery inside their unit, and I don't know, Glen will be able to tell us if that is legal or not. There's some problems with batteries in that regard. And I think firewalls and things, regulations in that regard. But it will give an opportunity then for people to install these things individually, but when the panels and the reticulation is actually owned by this. So yes, we've taken the same route as Reghard discussed, because that is what the case law is telling us, that if ownership is retained by the financier, if it is at all possible. I mean, the example that Reghard gave us on the previous discussion that we had about it was if ownership is, for example, retained on bricks in a building that you built, then it you can't retain ownership because you can't actually, it's not possible to remove. And as such, you can't retain ownership in that sense. But with the panels, it's a different story. They clipped on or they screwed on, so they are fairly easily removable. And as such, ownership is then retained by us in that regard. Don't know if Michael, if they are doing something.
Yeah, so we've done both. So we've done on a rental basis, in which case we do retain ownership. It's almost like a rent to buy. And, you know, then obviously it's we perceive it as a movable, and, you know, where a scheme does a full-on installation, we a little bit more simple. We just take sort of the ordinary security against the body corporate, and we would regard it as an immovable. So we don't retain any ownership then.
Flipping interesting.
But-
Sorry, Michael, please continue.
No, I'm just saying it, but it's certainly a very, very topical sort of discussion. And, Reghard does, sort of raise some sort of interesting points, so, I'm just a simple property manager. So I guess that's a lot to think about.
Far from it, far from it. The nice thing about working with both you and Willie in the industry is that you've got such an incredibly wide background. So you always think about it from so many different angles. This movable and immovable concept really only came to us. Mike Addison mentioned it from an insurance perspective. And, working so practically every single day, one doesn't really think about this legal theory aspects. You don't think about somebody installing something like solar to be removable, but it makes so much sense in the financing concept. Obviously, you're not going to finance something that you can't possibly take back if the person defaults. And in the schemes that we've been working with, Nicole, Matthew can agree or disagree. I think the majority of them have been going for the financing routes. It's not something that every single body corporate, has 60, 70,000, 100,000 Rand, whatever in their back pockets to go for solar installations. And I think that's a low quote, Glen. So very, very interesting indeed. Mike, would you like to come in from the insurance aspect for the movable, immovable issues?
Yes, good morning, everybody, and thank you very much, Reghard. Thanks very much. I always like to see things in boxes, and I think you really put them in nice little boxes for us, not so clever people to understand. So thank you very much. Reghard, also what you told us the other day also had me really thinking again, and I had to add another slide to my growing slides. I think as we've been progressing along over, particularly the last year, with all of the inquiries, and as we learn about solar, so our slide presentations get longer and longer. I'm sure the others find the same. So you had me also going to look at academic stuff. I've got my insurance academic book. I don't know if you wrote this one. No, you didn't write this one. And we were looking at things like insurable interest, because that also has an impact on whether who has an insurable interest in that item. And then I was referred to case law here, and I got a little bit more comfortable because it's fitted in with what you said and what the insurance companies are asking. Okay, so from our point of view, we can insure the stuff. I've had that cleared, and everybody got me running around asking all the insurance companies recently, and the insurance companies that we work with, we can certainly insure the stuff one way or another. So that's not an issue. It's just about asking the right questions. For example, one of the insurers that we work with probably mostly will, if it's being leased or rented, they want to see a copy of that lease agreement. I always wondered why, but I'm assuming that it's because they want to check for their insurable interest or the insurable interest, and that's probably why they want to see the copy of the lease agreement, but they're willing to do it. Another insurer at the recent NAMA Expo gave a presentation quite late at the Expo. You might remember, I'm not going to mention names, but it was a nice a little presentation, and they are that underwriting or that insurance company are actually going to be asking for an electrical compliance certificate. So it's a matter of who must do the compliance. They must provide that compliance. And then Glen can obviously illuminate us on what compliance issues should be there. But yeah, so from an insurance point of view, as long as it's compliant in all the ways that it should be, and it's, we can have some sort of understanding that it is there permanently. One of the questions I'm asking is, and I'm more concerned, I'm not so concerned about the panels on the outside. They're there and we can insure them. I'm more concerned about what's inside, because we can't see what's inside, and not that we're really particularly interested, but what happens is people are a bit naughty, as we well know, and they don't want to pay a premium for something that they have inside. And because maybe they're in a body corporate or environment, and well, they probably are, and they feel, oh, I can save a bit of premium by not insuring my contents. But actually, maybe that stuff is inside, it's movable completely. I mean, it might be on wheels, it might be I don't know, whatever. I'm not technically minded, but it could be very, very movable. And then one day when something does go wrong, then suddenly they phone us up and say, listen, I want to claim. Well, I say, well, what are you claiming for? So we need to somehow establish that something is noted as being installed permanently, or as an immovable in our eyes, okay, not in terms of the court's eyes, but certainly in our eyes, we just want to know that it's permanent and we can insure it. And that's as simple. Ours is quite simple. So from an insurance point of view, yeah, we don't have a big issue. It's very interesting. We do need to understand it though. So Reghard, thank you very much. And particularly if it's being financed, I'm obviously going to engage with Michael and Willie a little bit more about how we can maybe tidy up some of the insurance aspects for their sakes as well.
Perfect. Thank you so
Okay.
much, Mike. Abrie and Glen, could you please come in here with regards to the whole element of, your thoughts on the movable, immovable, and then, if it's removed, how would that work? How often you see it? How often you think it's going to be seen? And then Abrie, perhaps you could speak a little bit about, some things to consider before even looking at the actual installation process per se. And then perhaps, Abrie, your experience from a sectional title perspective.
Morning, Zerlinda and everybody. Thanks for the putting this all together again. You guys go to such effort. It's solar panels and solar geysers are two very separate sections of the business. One being solar thermal and one being the generation of electricity. Both of those, without question, from a practical point of view, can be picked up and moved immediately, like within under half an hour. So very quickly to do practically. I'm not going to talk about the legal stuff, who owns it and stuff. I have no idea. But from a practical point of view, the solar panels don't actually even sit on the roof as such. They sit on a substructure that would sit on the roof. So you would have a substructure that would be built on the roof, and then you would attach your panels onto that substructure. It's typically more difficult to fit the panels because you actually have to build a substructure around the roof initially, and then fitting the panels is purely sort of fitting them onto brackets, aligning them so aesthetically it's there's aesthetic uniformity, and it looks somewhat pleasing as far as solar panels can look pleasing. Solar geysers, slightly different. They're slightly more attached to the building. They still sit on a purpose-built frame, but that frame is typically part and parcel of the geyser. Without the frame, the geyser would sort of fall off the roof or crumble and those sorts of things. So it's slightly different, but pretty much the same. There is a purpose-built structure for the system to work on. In our particular instance, now not to pick on products, but in our particular instance, there are literally 3 bolts that would go onto a solar geyser that you would remove from the trusses, and the system actually hangs there. It's not actually physically bolted onto the actual roofing structure, and that's by design. On both of those instances, I've learned a lot from old Mike. Both of these instances, we move across the medium line with be it cables or be it plumbing pipes, which then obviously starts changing it, and Abrie can discuss that. But whether we're integrating into the electrical DB board or whether we're plumbing into the bathroom, or both solar components would at some stage cross that middle line. And that I think is probably where the tricky side of it is going to come from a practical point of view. If somebody were to remove something, they could quite easily, especially if it were an inverter or batteries or fuses or bypassing fuses, forget the electrical CIC that was issued back then. Somebody could bypass that or do whatever they needed to if it were inside the unit. So that starts playing to a risk factor. Vodacom, I believe Vodacom building in Cape Town burnt over this week. Panels burnt and caused a significant amount of damage. I think the biggest problem today with the solar space is we're racing ahead. The industry is racing ahead to satisfy this demand for power. And really, there's not enough homework been done on this, on these products. I'm talking specifically about lithium batteries. I sent an image the other day on a WhatsApp. You're not allowed to fly a lithium battery. You're not allowed to put a lithium battery in a plane, and for very good reason. We install them in our houses, but we really got to start considering whether or not it's the right solution. And I don't want to climb into specific products, but I think there's still going to be a lot learned. And I think the idea that in 10 years, historically, we've seen this surge and then die off, and surge and die off in terms of solar. And we're going to see a surge now because it's winter and everybody's chomping at the bit for some sort of security of supply or hot water or something. They're all going to be pushing ahead to get something installed now. And actually what you're going to see once summer comes and there's a little bit of a load reduction on the grid and Eskom becomes a little bit more stable, you're going to see this starts going away. And there's going to be a lull. We saw it in 2008. Every time there's load shedding, you get this massive surge and then it sort of dies down. None of this is talking necessarily to the ownership of the whole thing. I'm just conveying a message as to what the industry sees and how the industry typically deals with the solar and deals with the load shedding and deals with things. And it's always this surge and then die off and surge and die off. I'm just going to finish with one quick example. In 2008, when the first bout of load shedding started, the industry grew from 6 of us sitting around a table, bringing our own tea and coffee to the SESA meetings, which was SESA is the Sustainable Energy Society of South Africa, which was actually sort of the solar watchdog. We put together the Eskom rebate program with the Department of Energy for Eskom. And we grew from 6 of us to over 700. Everybody wanted to be a member because in order for your customers to receive any benefit, you had to be a member of SESA because of the code of conduct, etc. We don't have that in the solar space today. You have people that are flicking, green cards or solar cards or this or that or the next thing. All you have to be is a qualified electrician. And once you're a qualified electrician and you can issue a certificate of compliance on the basis that you integrate into the AC component of the dwelling. If you leave it as a DC system, you don't have to issue that. Once you integrate, you then issue a certificate of compliance and off you go. That doesn't control what people do thereafter, whether it's a centralized system in a complex where everybody's drawing off one system, which I believe we're still going to see serious issues with, or whether it's a decentralized system and you've got panels on everybody's roof for their own application, be it lights, be it whatever it is, a dedicated type circuit, or what we call a critical load for a specific individual unit. So one owner has one set of panels, one set of batteries, one inverter. There's no control over what people are going to do once that certificate of compliance is issued. And ownership could become quite difficult there, because if the tenant, which is probably 90%, or maybe I'm talking a lie, but it's probably a significant portion of the sectional title market, bypasses or doesn't do what they're supposed to have done in terms of maintenance of this thing or looking after it, and that then has a knock-on effect with the solar panels and causes a problem where panels start burning and this unit burns that unit down, or this guy's battery burns that guy's house down. I think it's going to become, there's an ownership and a liability thing where I think it's got to be looked at quite carefully.
Thank you, Glen. I think that gives some indication of the complexities, and the bit I want to share is basically also a huge gray area. Of course, when all the regulations was written and the whether you need building plans or not, these things have not really been spelled out. But what we have learned is that basically you need to submit building plans to council when you install solar panels. So immediately that put a responsibility onto the owner or then the body corporate to ensure that those steps are taken. Now, in sectional title, of course, as we know, that in itself gets complicated, and it's even further complicated by the fact that to get building plans approved for your solar, you will have to ensure that the rest of your complex comply as far as building plans is concerned. And I think me and Willie discussed it. I think we're still looking for the first complex that comply as far as the building plans are concerned. So that's the first point that one needs to take into consideration. And I think especially when you do huge a complex and you install 80 or 100 or 200 solar panels, I think that is more relevant than when you do one or two, although the law don't discriminate between the two. Of course, then the other factor that is also a given is that you will need to get a civil engineer involved to ensure that the roof is suitable and can carry the weight of the construction. And then, of course, the method of attaching. And again, I think in a perfect world where you only have qualified labor and people knowing what they do, you will not have to damage the roof. But again, in real life, that is not how it works. You have people, especially now where there's the big gap in the market, you have what we call the bucky builders, and they will achieve anything, but not necessarily without damage should these be removed. And therefore, I don't think there's one answer that can say, will it cause damage or will it not cause damage? There's obviously also various types of roofs, and it will be different for different type of roofs. And then, of course, there's also the aspect of some roofs that is still asbestos. And there we have a whole new set of rules and laws applicable. So, yeah, are you going to draw into it? How are you going to attach it? So I think from the building plan and the council's point of view, of course, the COC, the electrical COC is a given. Then a certificate from the engineer is a given. But then there's a lot of gray areas. One specific thing that we came across where there's pergolas, for instance, and owners or the body corporate want to put panels on them. Of course, if you put those panels together, it forms a solid roof. Whereby the pergola was no coverage, suddenly you will create area that will be calculated as coverage. So again, it might not be possible to get a building plan approved because the complex or the property might exceed their coverage. So there's various factors that nobody ever thought about it before, and there's no clear answers at this stage. But it is important to at least think about those type of things. And I'm sure as it develops, there will be more hard and fast rules created how to deal with it. I hope that brings some insight.
Fantastic. Thank you so much, Abrie. And I know that Philip would have most certainly agreed with you if he had been online. Yanni is traveling at the moment, so he can't actively participate. Sorry, yes?
Sorry, I just want to add that
Yes.
There's also legislation. SANS 10400 is also quite specific to weight distribution on a roof. Now, SANS 10400 is kind of the building standard. And
Is it just me that
bearing
lost Glen?
capacity.
Okay, there we go. Glen, sorry, we lost you for a second. If you don't mind just repeating.
Sorry. So SANS 10400 is also in place, which also protects dwellings and buildings and all sorts of things. And there's also load-bearing capacities on the roof. For example, a tiled roof weighs a hell of a lot more than an IBR roof. So structurally, you've got a very different capacity of weight bearing on one roof versus the other. And often these weight bearings, if you said to me you wanted to put 50 panels on a roof, you'd be joking if you started sort of trying to get an engineer and all those things to look at it, because the weight bearing capacity is quite capable. So the point being is not to disagree with Abrie. I fully agree with Abrie, but it's also picking the right contractor to do the work, because if you know these things, if you've been doing it for long enough, you'll be able to tell at the drop of a hat, right, 100 panels on a 50-meter roof, that's going to weigh 300 kilos. It's just the weight to Michael Schaefer on his own. It's easy.
I agree.
Oh, you're so rude today, Glen. Old Mike and the weight of Michael Schaefer, gee whiskers. You guys are clearly
he gives me a hiding on the bicycle.
He's a cheeky bugger.
On the bicycle, so I have to tease him now and then.
There's a special relationship there, guys. See, we're not all professionalism and fancy CVs. We have a little bit of a fun side as well. There's a couple of good questions, Glen and Abrie, in regard to the area versus the number of panels and things like that in the chat function. If you don't mind taking a look and maybe putting your comments there. Dilen, would you like to perhaps wrap up for us from a sectional title perspective and some of the interesting things that you've come across? And then Matthew's just going to give us one or two more pieces of information and we'll call it a day.
Yeah, thank you, Zerlinda and team. It's always amazing being part of these conversations. I think a lot of us have come to realize that sectional title law is not just straight and narrow, and there's always an answer to what's happening. Most of the time, I personally feel like the answer is a yes, but, or a no, but. So I think a lot of people might be even more confused after this conversation, but I think Reghard put the legal perspective quite clearly, and just before coming to the sectional title issues, I'm just going to summate what he said. So remember, when we try and determine whether these types of installations are of permanent or non-permanent nature, I mean, that relates to the ownership. If it's permanent, it's owned by the individual who owns the property, and if it's not permanent, the ownership might vest somewhere else. So there's three requirements: nature and purpose of the attached thing. So is the thing that we're attaching actually capable of permanent attachment? The second thing we're looking at is the manner and degree of the attachment. So the attachment must indicate that the thing is permanently attached. As confusing as that might be, but how are we attaching this to the roof? And coming to all of these Roman law principles, it actually stuck with me a term called nagelvast, and perhaps excuse my pronunciation of it, but it simply means as firm as a nail. So if something is attached as firm as a nail, it seems to suggest that that might then be permanent in nature. And then the last requirement, and probably the most important requirement, is the intention of the annexer or the intention of the person who's actually now attaching this to the property. And that relates to the presumptions that Reghard amazingly gave to us. And this is now where we can deal with this presumption. And I actually want to just leave this out there in relation to the difference between body corporates and HOAs. In a body corporate, the roof or the barcade roof is seen as common property. So the owner of that property is the body corporate. And in those instances, when we look at the presumptions that Reghard gave, when a tenant in a conventional tenant-landlord agreement now attaches this, there's a presumption that it is temporary in nature and that it should not be permanent. And I mean, we don't have case law on this aspect, but I can't see in a body corporate member relationship where a member actually now attaches something to the common property that this presumption will not apply. So I think from a body corporate perspective, this presumption most probably be exactly the same. And then again, my warning or my suggestion in this regard is before we now start attaching solar things, perhaps consider entering into agreement where this intention is made clear. And what we need to understand with this third requirement, this intention requirement, this is a subjective test. So it's not an objective test. We're not looking at the reasonable person. We're looking at that specific person's feelings. So, and their intention. So that makes it quite difficult for a body corporate, for example, if they now try to insist this is our property, it's going to be a difficult argument. So I think just to eliminate this clarity, or to eliminate this, whether or not this is permanent, let's perhaps suggest entering into agreement so that there's clarity at the start. I mean, ultimately, the body corporate will be tasked with consenting to these types of things, and there we would need clarity as to who is going to retain ownership at the end of the day. From an HOA perspective, it's much different. The roof there is the ownership of the member, the individual member. So there, it's a whole different context. And then again, coming back to the presumptions, it seems that if an owner of a property then attaches something to his property, it is seen to be permanent in nature. And then again, when this member now sells this property to a new buyer, to consider clarifying this in the sale agreement. Because if you don't clarify this, it's again going to come to this whole issue. What was the intention when we sold it? Did we intend to sell it with the solar fixture or not? So again, this is a very interesting thing. And then also from a centralized system point of view, where the HOA now decides to install solar for all of the members in the scheme or in the HOA, again, consider where are we going to install this? And now it's the flip side of the coin, because now we as an HOA might have to install this on the roof of an individual member. So again, they consider things such as who's going to maintain this, if there's damage on this specific member's roof, who is responsible for this? So all of these things, I think, should be clarified beforehand. Otherwise, we're going to get involved in litigation. And unfortunately, I mean, I've come to realize in the sectional title industry, a lot of individuals love to fight. I don't know where everyone gets the money to conduct all of these fights. I'm not complaining as an attorney, but ultimately it is quite interesting to see people fighting. And I think property is the start of most disputes in sectional title. So yeah, that's just my 10 cents on it. I think eliminate any uncertainty at the start before we now start installing solar. Thank you, Zerlinda.
Thank you, Dilen. It's always so great for you to introduce and to end up. You've got such a great way of really summarizing matters quite succinctly. Although I would expect it to go on for a lot longer, because you charge a heck of a lot more than we do for your time, which is very, very important. And that's also why you offer your initial consultation free of charge, if I remember. Am I spelling something incorrect now? Is that still correct? Still correct.
Not at all.
So that's not something that we do. So ladies and gents, if you would like to consult with Dilen, I highly recommend it. You'll get that first consultation free of charge. So I'm sure that he'll share a lot more information with you. Dilen, on that note, thank you as well for really chatting about the HOA concept. We've been trying recently to give a little bit more information to HOAs, and it's so difficult because each HOA rather is needing to look at its constitution or its MOI, but there are some principles that are standard. So we're trying to give more to homeowners associations. Where you've got ideas, please do share them with us. Just 2 new dates that have come up fairly recently. One this morning that I'd like to share with you is, if you're based in the Western Cape or you'd like to come down to Cape Town for a long weekend, the NAMA Western Cape Committee will be holding a breakfast on the 25th of August. That is the date that has been confirmed. It's a Friday, the 25th of August, and that will be held at the Durbanville Golf Club, where it is normally held for the breakfast events. The speakers and more information will be made available at a bit of a later stage. NAMA will also be holding the KZN Expo. So we held the Johannesburg Expo. The KZN Expo is going to be the 15th and 16th of September. That is a Friday and a Saturday. So for those of you that are in that area or be traveling, a lot of us will be there as well. So keep that in mind. Matthew, if you could please wrap up for us, and then we really will call it a day. Ladies and gents, if you've got any other questions, please feel free to contact us. There have been a couple that have come through on the chat, and my colleagues have been answering those, but feel free to contact us. Everybody's contact information has been shared. Matthew, over to you, and then we'll close for the morning.
Thanks, Zerlinda. Well, firstly, just a special thank you from my side and from the whole team to all of our speakers this morning. I've really appreciated your insights into this continuously evolving, complex topic, and I'm sure all the fellow attendees found it as informative as I did. And if anybody has any questions further, you can engage with our team on Facebook or on our neighborhood community schemes platform. If you haven't already, please check it out. We would highly recommend, if you are a managing agent or just an owner or occupier in a community scheme who's curious about an issue, doesn't have to relate to solar specifically, anything, or you just have a question which you'd like an industry expert to answer for you, that you sign up for our Managing Agent Plus or Common Property Plus packages on our neighborhood, where you can have access to an expert over there. And then if you're a service provider in the industry, please do sign up for our scheme support package, where you'll have the additional benefit of being able to advertise in the service provider directory on the platform. And Nicole, Nell, and I have also really enjoyed recording our segments for you all, which is Nicole's daily advice and Matthew's memos for you all. So please have a look out on our newsletter for that. And if you haven't got or signed up to our newsletter, have a look on our website to access those links. And once again, thank you all for your time. Thank you for taking time out of your morning, out of your busy schedules to join us for this topic and for this discussion. And I hope to see you all again next time.
Thanks, everybody. Keep well.
Everybody.
Bye-bye.
Thanks, everyone. Goodbye.
Bye.